Welcome back. Here with us on Urban Debate on Mirror Now. In February last year, the government, through a Gazette notification, had launched the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. Like OTT players, the digital news websites were mandated to follow the Code of Ethics and three-tier grievance redressal mechanism. At least 10 petitions were filed against the applicability of the IT Rules 2021 in the Supreme Court and the High Courts of Delhi, Madras, Bombay, Kerala, challenging the constitutional validity of these rules. Now, Part 3 of the IT Rules 2021 pertains to digital news media and publishers, and it prescribes a three-tier structure and code of ethics. However, the Bombay High Court on 14th of August and Madras High Court on 16th of September had stayed the operation of the three-tier structure and the code of ethics. Now, viewers, a right to information application has revealed that Centre had sought details about digital news media publishers under the new information technology rules. The Ministry of Information and Broadcasting, in the reply to this RTI, has stated that 2,100 publishers of news media and OTT platforms have already furnished their details to the centre. However, the government officials say that the Bombay High Court had stayed only a section of the new IT rules, not all the provisions. It claims not all provisions of IT rules were stayed by the courts. So is the government on the right side of the court order? Well, tonight we debate, are digital media platforms being asked to comply with rules stayed by two high courts? Let's try and decode this. We are joined by N.S. Napinai, who is an advocate, Supreme Court and founder, Cyber Saathi Foundation. Desh Ratan Nigam, Senior Advocate, Supreme Court, will be joining us. And Khushbu Jain, Advocate, Supreme Court of India, Cyber and Privacy. Thank you very much, all of you, for joining us here on Urban Debate this evening. Khushbu, let's begin the discussion with you. What is your understanding of what the RTI has revealed as the questions are now being raised, that there was already a stay on these rules by Bombay High Court, despite that the government had sought the data and the data has already been given?
So if you look at stays, whereas different jurisdictions are concerned, whereas Bombay High Court is concerned, whereas Madras High Court is concerned, is specific or pertaining to specific rules. Now, those rules are that no coercive action will be taken against any of the media houses or platforms in case of non-compliance with whatever has been stated in the rules. If you look at Rule 9.1 and 9.3 is what has been stayed, but none of the orders specifically say that there is a stay, whereas the entire rules are concerned. And whatever the understanding which I have is what exactly Government of India is asking is details asking them to furnish details as to the subsidiaries and to register themselves basically that they exist or they do not exist. And so far, I think 200 plus was the number which has been intimated to the Government of India, including OTT platforms, including digital media houses and other media houses. So in my understanding, in a nutshell, it's not exactly a stay order, whereas the entire rules are concerned, but pertaining to specific portion of it.
Okay. So, Ms. Napinai, is the government on the right side of the court order?
The complexity here is this. Now, if you look at the order, it is specific to 9.1 and 3, but 9.1 and 3 also covers other rules. However, the provision for asking for information comes under Rule 18, which technically may not fall within the other rules which I just mentioned, which 9.1 and 3 will cover. So if you're asking, are they in violation of the orders of the court? Not necessarily. However, is the government wrong in asking for it when Part 3 itself is under a cloud? I would say definitely yes. The reason for it is, and I do not know whether the petitioners articulated this problem at all or not, or whether despite their articulation, the orders were limited to 9.1 and 3. But fact remains, and I've been very vocal about it, that Part 3 of the intermediary guidelines cannot really sustain the test of judicial review, in my opinion. And the reason for that is it's way beyond, it exceeds the parameters laid down by the Parent Act here, which is the Information Technology Act, and specifically Section 79. So and this is what is called as delegated legislation, Heena. So when you're exercising your powers under delegation, you cannot exceed the ring fencing which the Parent Act does. Here, the Parent Act applies to intermediaries, and intermediaries are specifically those who do not have control over the content which is being published. And 8 clearly talks about publishers who have control over the content which is being published. Therefore, the opposition ought to have been, and I'm sure it was in many of these cases, to Part 3 itself. Whether the government official is right in saying some of these sections are not applicable, yes, it may not be covered under the order. It is not covered. Let me be more precise. But should the government go ahead and do this when this particular portion of the intermediary guidelines is under judicial review? That's where I beg to differ in terms of saying that it is a little brazen for the government to say, if you have a problem, you go to court. And we will keep asking for things which we want. And there, I believe that they should have exercised discretion, stayed their hand, and waited to see what the outcome of the petitions are likely to be.
Okay, so to simplify it for our viewers, Ms. Tapina, you're telling us that Part 3 is under judicial review of these particular rules, and under that provision, the government should not have really asked for details of these particular companies, but now the data has been given, and let's first try and understand what Mr. Desh Ratan Nigam has to say about what has happened in this particular case, what the RTI has revealed. Then of course we can talk about what should now be happening from here on. Mr. Desh Ratan Nigam, what are your opening comments? Is government on the right side of the court order in your view?
Let me carry forward the discussion as laid down by my 2 previous panelists. One, the Rule 16 has not been stayed, which has been very categorical, and they have said under Rule 16, the contents of 69A of the IT Act can be looked into. One, there is no coercive action which is taking place on the part of the government. They are collecting information which has not been prohibited. And they have to register themselves. It is, and then subsequently it will be decided. No doubt that these rules have been framed under delegate legislation under the IT Act, and the courts in its prima facie opinion thinks the Parent Act does not provide that delegated legislation for this Part 3 at least. However, the courts are also clear, they have not stated Rule 16 also. So collection of information can be, continued without taking any coercive action. So government as of now is on the right side. There is no violation of the court order itself. And one of the important aspect of this rules is that although it provides a grievance mechanism for the people who are aggrieved of it, it provides no right to appeal or grievance mechanism for publishers, which is very, very important because you have to give a level playing field to both the parties. So that aspect has not been taken into consideration. So principles of natural justice also require that both parties are on the same level playing field. The intention of this legislation was very clear and was very good also, because government said they wanted to have a soft self-regulation on behalf of these publishers and to provide a level playing field for the TV channels as well as print media, so that everybody, because they are covered under the Press Council Act and the Cable and News Network Act that you have, and there was no regulation on this side, and they could publish anything and get away with it. So this was, however, it's a technical difficulty, because when the Parent Act does not provide for delegated legislation, so the government may be mulling a comprehensive separate legislation for digital media and OTT platforms for news and current affairs and curated content.
Okay. It is a very, very technical issue. So let's try and simplify it for our viewers further. Mr. Deshrathanigam, another question for you. Now, the government officials are trying to suggest that it is the Chapter 5 that deals with furnishing of information. Now, Chapter 5, if you look at the guidelines, that actually falls under Part 3 of the rules. So when that is stayed, when that is under judicial review, then why should the government ask for information at this point in time is my simple question.
Entire Part 3 has not been stayed. Very simple. Parts of it have been stayed. So let us be very clear. The government is very clear about it, and the entire Part 3 has not been stayed.
Okay. Ms. Napine, will you like to respond?
Yes, please. Thank you. So my earlier speakers are not incorrect in saying the entire Part 3 has not been stayed, and that is not my point also. But what the latter part of the word the gentleman said is what counts here, which is that the entire Part 3 is still under judicial review. That's the distinction here. So when you know that this is exceeding the Parent Act, you know it's under judicial review, you know that nothing further can be done with the information. To then collect information now is nothing but expedition, which is not warranted at this juncture. So effectively, my concern is this. Now, you are collecting information at a stage where you know that these are going to be subjected to judicial review. And tomorrow, if the courts were to hold that Part 3 is ultra vires and therefore needs to be struck down, and they do strike it down, I've seen often in earlier cases also where the Supreme Court did not venture forth to then say what should be done with the data already collected. So here is my heads up to all the petitioners. One, if you want to ask for further protection, I think you should, because it's the entire Part 3 and not just parts of it which you need to protect yourself against. And two, remember, either you need to stop collection of data or protect yourself against the data already collected with a specific order for its deletion.
Okay. So, Khushbu, the sense that we are getting right now that it's a very, very technical issue, and that's the reason why the government also seems to be right in asking for data. But the companies now, as government officials are suggesting, if they have a problem, they can approach court. They can, also say that they do not want to share the information.
See, the problem here is we are talking about, has there been any contravention or has there been any infringement of the court order by the government? Let's understand that what exactly is the information that media houses, that the government is asking, and specifically time. That the information which we're talking about is since the start, they gave the time that it's, after the rules, 1 month is given for you to furnish your information as per Chapter 5 of the rules which you're talking about. Now, we are not asking you details as to what exactly are the grievances that has been come to you, what are your responses to it, nothing. It's just they're asking you to furnish information pertaining to, whereas your business are concerned, whereas commencement of your business yourself, and practically to register for government to know that how many entities are there. As I said earlier, also 40 OTTs have registered so far, and somewhere around approximately comprising 1,500 have registered. Now coming on the part that only Part 3 of whether the entire Part 3 has been stayed. Had the court had an intention, see, you cannot say that whenever a new rule or an act comes in play, if a portion of it has been challenged, you practically want to make the entire act as, that government cannot practically impose any of the rules and regulations. Had that been an intention of the court, if I'm talking about specifically about the court order, the interpretation, it has specifically talked about staying certain portions of it. And whereas today's, act of the government of India is concerned, it's not in contravention to any of the stays orders which has been passed by the courts. So in a nutshell, the specific portions which were being stayed, there has been a compliance by the government. There has been no overreach. There has been no action by the government where they are trying to overreach, whereas judiciary is concerned. Now coming back on the part whereas judiciary is concerned, whereas whereas intention of the judiciary is concerned, it should have been very clear had there been an entire stay, had there been an intention. It's not the information, as I said, it's not entire information that you're practically asking to enforce the part 3. No, the only portion which was going on since start is with regard to chapter 5, furnishing of information, nothing to do with other portion of it, which is rule 10 or other rules of it where you have to furnish details in qua with whatever has been stated in 9.1 and 9.3. In relation to that, the committee 9.3, the 3 level which have been there in compliance of those 9.3, the things which have been expected out of the process to be done, nothing so far has been done, whereas those parts are concerned.
Okay, Ms. Napinai has a different point of view. Yes.
I just wanted to clarify that the overreach is with the act, the part 3 itself, the regulations itself. That's where the difficulty arises. See, I'm all for regulation, which brings parity between print and other digital media. I'm not against that, but it has to be done correctly. We are a democracy, and we have to follow due process of law, including in creation, formulation, and implementation of the law. If we are going to take a stand, how does it matter until it is struck down? Let's keep at it. Then we are really setting a precedent which is going to be.
But Ms. Napinai, as Mr. Deshratan Nigam also, told us that entire part 3 has not been stayed. So clearly, it'll be then incorrect to say that if government is asking for some information under these new rules, then it's incorrect. Don't you agree?
It is incorrect for them to ask for it, considering it's under judicial review. If you're asking, it's incorrect because there is no stay and therefore they are permitted to ask for it. Yes, there is no stay, but that's a technicality. Do you still want to go ahead and ask for something? Because what I'm trying to say here, Heena, is this. A law is passed, which is an overreach in itself. It's disproportionate. It's forget about the proportionality. It's an overreach. It goes beyond.
But that might be your point of view about the law. Now, there is a rule that needs to be followed.
Bear with me for 1 minute. That's my point of view of the law, but that's not what I am on. It's about the attitude that I am on. So the attitude here is that I will pass a law which is an overreach. Until it is set aside, I will keep using it the way I want, and I will then see how best I can utilize that information later through some other lawmaking process. Is not the correct way for a democracy to function. The whole idea of why you have checks and balances in terms of how a law can be formulated and implemented is to ensure that...
Yes. Mr. Deshratan Nigam also wants to respond.
Yeah, let me tell you, as we all are lawyers.
My other guests disagree with you. Yes. Mr. Deshratan Nigam first.
The benefit of this discussion is that we all are lawyers here. Let me simplify it. We all have to adhere to the order.
The idea is to understand it. It's too technical.
Yes. No, it is not at all. Let me put it in very simple words, that we all have to adhere to the orders passed by the court. And if the courts wanted, they could have stayed Rule 16 as well. The government of India says that they have a power. They have a power under Section 87, subsection 2 and 2Z. And however, the other side is saying it is a different section altogether. So the fact remains, if court in its intention wanted to stay everything, including 16, and 16, they have prima facie of the opinion that it flows through delegated legislation of the IT Act. So it can't be. I mean, they have made their minds very clear on 16. So because 69A has not been struck down, it still holds so far as sovereignty and integrity of India is concerned, or criminal offenses of
One at a time, please. One at a time, please.
But it's not
let Mr. Nigam complete.
It's 18, under which information is sought.
Please don't interrupt. The fact remains that...
Okay, Ms. Napinai, let him complete. I'll give you time to respond. Yeah.
The fact remains that the courts have not struck down. Neither they have stayed anything as of this moment, so far as 16 or 18 is concerned. So government is all over the time. If you look at the way acts are, implemented, only the portions which are stayed or not implemented, the rest of the act continues. Otherwise, the entire government machinery based on that particular act will crumble. If you extrapolate your logic that it should be extended since it is under judicial review, that way it doesn't happen. Otherwise, all the acts and the sections,
Okay,
even the entire
okay.
IPC could have been stayed.
Khushbu.
Only certain sections. So
Okay, Khushbu.
I absolutely agree with Deshratan ji that if to go by the logic which Napinai ji was talking about, then practically there's no purpose of stay. Why do we ask for a stay? Because I can practically challenge any act in the court and then think of that I have challenged some section in the court, so the entire act should not be should not be executed or should not be should stand with nothing should be done whereas those acts are concerned. So there's a purpose of a stay, and whereas court is concerned, whereas today's topic is concerned, we are not talking about whether 9(1) and 3 were overreach, whereas government power with the government is concerned, whereas existing acts are concerned, but we are specifically talking about the part whether the action of the government requesting for furnishing certain information under Rule 18 of Part 5 of Chapter 5 of the rules are in contravention to the orders or stay passed by the courts, by the various courts, and the answer to that would be no. It would be in a negative, because it has been, whereas all the courts are concerned, they have specifically stated certain portion of it, and it has no effect, whereas Rule 8 of furnishing information is concerned.
Okay, so government is not on the wrong side of this particular order. It's on the right side of the order. That's the view of Mr. Deshratan Nikam as well as Khushbu. I want to give you the last word, Ms. Napinai.
Yeah, thank you. And sorry for interrupting, but I was just correcting again on a technicality. The provision that Deshratan ji was referring to is not the provision under which the information has been sought. 16 is linked to 69A for blocking, which has been upheld by the Supreme Court. That's not the issue here. 18 is under which the information is being sought. The reason why I'm expressing concern is actually being missed by both the speakers. They are again doing this, we're all lawyers, as somebody just pointed out, and we don't talk about black on white. We don't talk about is the government right or is it wrong. We live in the gray area, and the gray area here is it's not about whether if you just file a case, you will it tantamounts to a stay. No, it does not. What is specifically stated by a court is exactly what works. And in that sense, I'm totally with the other speakers. The concern here is that where the entire portion, that is Part 3, has been contested as being an overreach, and it is so, and you yet exercise the rights under that, that's the part of which I'm saying is brazen, and that is being done consciously.
But even though it has been challenged, the stay is not on the entire Part 3. I think that's the view of the other two guests. That's the view of the other two guests. Even though it may have been challenged in the court, but there's not a stay. So we can't really call it a violation then.
It's not a violation. That's why I never
call it a violation then.
I said it was a brazen act. I didn't call it a violation, and I stand by that.
Can I come in for 10 seconds?
Okay. Opinion. It's a strict
interpretation. 10 seconds. Khushbu and Deshratan Nikam.
See, let me tell you one
Khushbu
thing.
First, then Mr. Deshratan Nikam.
Very into it. It's a clear, strict interpretation of what has been stated and what has been done, whether that contravenes or not. There is no gray area over here.
See, let me also point out what is brazenness. Brazenness has to be defined in terms of law, not in terms of literature. Please understand. And what you're talking about, some kind of an ethics. Our law consists of ethics itself, and morality is inbuilt in our ethics. So it has to be strictly governed by the law and the orders passed by the court. So brazenness you have to define in terms of law, not by literature.
Whenever we seek for an order, I'm sure all of us, three of us are aware of it, we ask for it for just, equity, and conscionable. And equity is built into it. I don't think I need to emphasize this
Well,
more.
to me, this actually looked like a courtroom today, but I am not a judge, so I can't give any verdict here. I will just leave it here. Thank you very much, all of you, for explaining to us this very, very complicated issue. We'll see what Centre now officially has to say, whether, it has followed the order in this particular case, or it has, in fact, breached that. So that's something that we'll try and get from the government as well now. But for the moment, appreciate you joining us here on Urban Debate on Mirror Now.